Hi there, Derek Walker from SMTI. Every so often, decisions are made at the courts and the tribunal, and they have an impact. Strata law, at the end of the day, isn't perfect. There's some areas where it mentions very little, there's others where it's a little bit ambiguous. When these situations arise, ultimately, we all sit back and wait for a decision to be made to guide us moving forwards. What is the right way to act if the laws aren't crystal clear? Well, this is one of those situations. I also understand as a manager, you don't have the time to be sitting there reading decisions all day. So when something really important comes across the desk, I'll get in touch and let you know. And that's what I'm doing today. So, of course, at the outset, not legal advice. This is case information. I'm saying to you all, key information, this is the circumstance, and this looks like the impact is going to be A, B, and C. However, you still need to occasionally reach out to your legal practitioners for further advice. So please keep that in mind. What is the situation? Ultimately, the question is, are lot owners' private email and telephone contacts fair game for other lot owners to obtain? For those that have been in the industry long enough, the most common position in the past has been this. Anything on the register, yes, you can have a copy. However, emails and telephone in the past have been treated as private, so unless the owner of those details gives permission specifically, sorry, emails and telephone numbers, we can't pass them on without their permission. But anything on the register, you can have. Now, what does it say in the Act? Section 144, Division 1, gives us a long list of what records an owner's corporation must keep. You will note in that list on the right, doesn't mention emails and telephone numbers. Under 146, it then provides a framework for individual lot owners to either inspect or get copies of those records. In 2021, the Act and the regulations were amended. Importantly, in the regulations, they added 11A, you can see on the screen, additional records. I'll quickly read. In addition to the records in Section 144, an owner's corporation must keep the following: the telephone number and email address, if any, of each lot owner. Now, of course, the complication here, one of those points of contention was this wasn't under Section 144. Section 144 was saying you've got the right to inspect records for free, anything under 144 Division 1. And then 11A was created. 11A was not under the same division. So therefore, when Section 146 was stating you can inspect records for free under this division, some managers were saying, well, this information isn't under this division. Of course, from that point, this is the point of contention. We're at loggerheads. Party one is saying, well, hang on, emails and telephone numbers, that's not part of the viewable, attainable records. Whereas party two is saying, I want the emails and telephone numbers for the other lot owners. I believe they are part of the owner's corporation records, and therefore I should be able to get a copy. The whole purpose of having the tribunal is to give us a way through. When there is an argument on both sides and it's unclear, we look to either the tribunal or the courts to make a decision to guide us forward. And that is exactly what has happened with the St. John decision. That exact situation. A lot owner has asserted a right to emails and telephone numbers. The owner's corporation has said no. VCAT has said, quickly, given that the common property in a plan of subdivision is collectively owned by the lot owners as tenants in common, it is entirely consistent and logical that there is in the OC Act a presumption in favour of access to any record of the owner's corporation accessible under 146.1 and 146.2. You can see 146.1 and 2 on the screen. One of the key things that's being pointed to here is 146.1 is saying lot owners can for free inspect records under this division. And then under subsection 2, looking closely at the second last line, payment of a reasonable fee, provide a copy of any record of the owner's corporation. This is one of the key things that's been looked at by VCAT, that word any. So they're saying, well, you can only look at for free records under Division 1, Section 144. However, you can, for a fee, pay for and obtain a copy of any record held by the owner's corporation. And within that zone is emails and telephone numbers if they are on the files. So there is the key decision. This does raise a question. If I'm a lot owner and I don't want my telephone number or email given out to other lot owners, what can I do? Well, apparently there's only two options. Option one, under Section 172 of the Act, you can get an order from VCAT, which will restrict access to your records. That seems like a pretty significant process to go through just to say, I don't want you giving my phone number out. Or option two, which I must say at the outset, in my biased opinion, is not a practical solution. Never provide your email or telephone number to the owner's corporation. Of course, if an owner wants to opt in for email communications for levy notices or notices of meeting for meetings, it's going to be on the file. So that second one, whilst technically it is true, pretty unhelpful. If I was a lot owner, I'd want the owner's corporation to have my mobile telephone number in case of an emergency, fire, flood, insurance claim, whatever the case might be. They'll give you a call and say, we've got a problem. I don't want to withhold that just so that there's not a threat of a vexatious lot owner calling me at midnight on a Saturday night. So yeah, quite an interesting decision that has been made. General commentary to close this video out. From a positive perspective, this does make it easier for lot owners to get in contact with each other and communicate. There's no doubt that that's a positive. Of course, every coin has two sides. The negative side is if this is used for negative reasons by lot owners. If there is a lot owner that chooses to harass another lot owner, they'll be saying, well, how on earth did they get my telephone number? And the short answer may be, well, there was a VCAT decision saying emails and telephone numbers were openly accessible for all lot owners unless there was a restriction ordered by VCAT. So you can, of course, see this is still a contentious matter, but nevertheless, the decision has been made. The decision has confirmed the manager doesn't own these records. The manager is a custodian of the records for the owners corporation, but they don't own it. And it does seem to override that long-standing privacy protection in place whenever these requests would come through, which is we'll ask if we can pass on the information, but we can't without the lot owner's permission. It seems to be doing away with that. So the right to opt out of this or disconnect, it's not simple. You need a VCAT order, or as mentioned, to never have provided this information to the owner's corporation, which isn't really a practical thing. As always, everything in Strato, nothing's simple. So if you have one of these circumstances come across your desk, I would strongly suggest you get in touch with your legal practitioners you deal with in this space, your Strata specialist lawyers, for advice. One of the complex aspects of situations just like this is this. VCAT members are not bound to follow the decisions of other VCAT members. If in 6 months' time this comes up again, there might be a decision made and the member might say, I completely agree with the St. John decision, I reaffirm it, I agree, open access. They might also say, I don't agree, I make a different decision, because they're not bound to follow the same decision. And I realize this is an unhelpful thing to mention, but this is exactly why my commentary in closing is to seek legal advice. If this was bound by precedent, it would be a completely different situation. Is it a strong indicator of the way that future claims may go? Yeah, it's definitely an indicator. Is it a guarantee that every future case will go the same way? No, it's not a guarantee. So like all situations like this come up, really interesting indicator, a very strong direction to point you and your owner's corporation clients in when these questions come up. If I were the manager in that situation and this came across my desk, I would call my local friendly Strata lawyer and say, this is a request. I'm aware of the St. John decision. How do you recommend we proceed? I hope this has been of some assistance. As always, any questions, please do reach out, and all the best.